Good afternoon. I guess it is good afternoon for most of you, maybe good morning for some of you. My name is Jovan Kurbalija. I'm director of DiploFoundation and head of Geneva Internet Platform. And I have a great honor to moderate today's session on unpacking EU regulation on digital markets and services. This session is co-organized with the European Union delegation here in Geneva, French presidency of European Union and permanent mission of France in Geneva, and Geneva Internet Platform, where I'm connecting from. This is really timely discussion because there are many questions on digital markets and services. And there is a major breakthrough, I would say, for French presidency, because many estimates were that Digital Service Market Act that it would be difficult to get both acts passing during the first 6 months of the year, especially in the context of very turbulent geopolitics and international developments, which all of us are following carefully. And somehow history accelerated in negative, but in some areas in positive ways. And one of the positive ways is serious discussion about content moderation and content challenges. It's happening in Brussels, and obviously everybody is following carefully so-called Brussels effects on the digital governance. But it is also happening in headquarters of big tech platforms. Elon Musk is trying to reform Twitter and to see how to manage content differently at these major tech platforms. We have very unique context with many, let's say, tectonic plates shifting in the digital governance and digital economy. So it is an excellent time to discuss two concrete developments coming from European Union. Digital Market Act, DMA, and Digital Service Act, DSA. Be prepared to learn the new acronyms. If you thought that it would be enough to memorize GDPR, we are getting more and more of this. And probably GDPR is one of the reasons why people are alert about future developments, because GDPR has had major impact on data governance worldwide. Therefore, in addition to European Union, United States, many countries are following developments around these new acts, DMA and DSA. And we have an excellent lineup for today's discussion. Today's discussion, which will follow Diplo agile style of having our sort of presentation with panelists, but also having questions and comments in the chat, and that question and comments will be moderated by my colleague Pavlina Iterson. Our panelists today are Ambassador Henri Verdier, Ambassador for Digital Affairs from Ministry of Foreign Affairs of France. Mr. Prabhat Agarwal, Head of Digital Services and Platforms Unit at the DigiConnect, Digital Director General for Communication Networks, Content and Technology of European Commission. From Geneva Internet Platform and Diplo, we have Ms. Marilia Maciel, Head of Digital Commerce and Internet Policy at Diplo and Geneva Internet Platform. And they will bring us different perspectives and different angles to this timely and important discussion. Therefore, in brief, follow carefully our panelists and what they have to say, and they can say a lot on this important issue. But also make your comments in chat, ask questions, and whatever you wanted to ask about DSA and DMA, it is now the right moment to ask, and we will answer in chat or provide follow-up comments. Without further ado, I would like to invite Ambassador Verdier, Henri, to reflect on this major, I would say, breakthrough during the French presidency in very complex circumstances. Henri, what was the sort of magic that you did in order to pull through these two important acts of huge relevance for digital governance. Over to you, Henry.
Thank you very much, Jovan. A great pleasure to be with you. I didn't know when I did accept your invitation, but you know that we don't have any more ministers in France. So I'm also representing France in the digital G7 today. So I might be a bit not so long with you as I did want. The magic. So first, I do agree with you. The agreement reached on the night of 22 to 23 April, so you are really in the actuality, is very important and probably as important as the GDPR itself. And maybe the magic things was a real sense of emergency, because we have to face disinformation campaign, misinformation, radicalization, violent extremism, and everyone now, if I'm understand that we have to make something, and probably a consensus on the analysis of the topic, because even 3 or 5 years ago, we had some dissensus on how to understand what's happening. And a lot of researchers, the work of some economic researchers like Jean Tirole, the French Nobel Prize of Economy, of course, a lot of whistleblogger like Frances Haugen did share a point of view here. And if I may, would love to share with you briefly this consensus.
Please go ahead.
And the mistake we did. So actually, let's start with a short story. In 1917, we did invent Internet. Internet was just a network of computers, but as you know, a resilient, decentralized, open network. And we all decided, more or less, that the best way to govern Internet was a real multilateral, multi-stakeholder approach. So we did build some forum to exchange about this, the Internet Governance Forum, ICANN, etc. And we did protect the free, open, and secure, and decentralized, and multi-stakeholder and neutral Internet. Net neutrality was very important. In 1990, Tim Berners-Lee did invent the web. With the web went the user-generated content issue. And so the web is Internet for crazy people, for everyone. And here we had to face a first set of issues like terrorist content, child abuse, child pornography, etc. And we didn't think a lot in US, in Europe, everywhere. And we decided, which was very important, that the hosting services, the machinery is not in charge of content regulation, and that law enforcement, police, justice, some administration makes the job, and that the main duty of the platforms, the hosting services, was to duty of compliance with the request of law enforcement authorities. In Europe, this is a regulation passed in 2000, at the turn of the millennium. In France, it was injected in the French law in 2004. That's important because 2004 is a year where Mark Zuckerberg did launch Facebook. And then 2005, it's YouTube, and 2006 is Twitter. And they did present themselves, those platforms, as hosting services. So they said, we are content neutral, we cannot regulate the content, we cannot filter the content, we are just hosting services. We will remove whatever you will ask us to remove, but we don't do more. And we did believe them. And probably it was a mistake. It was a mistake because they do regulate the content, because they do promote some content for a very specific business model, which is a personal advertising model. So they have a lot of algorithms to filter, to curate, to promote, and not just the content, but the content and your friends and the advertising you do receive and a complete ecosystem of information. And they do this for a very specific business model, which is personal advertising. And to make a great personal advertising, you need a lot of data for everyone. And to have a lot of data, you need a lot of contacts. And to have contact, you need addiction. And to have addiction, you need to propose something that people like sugar or drug. So something you deeply believe in, something that make you angry, something that make you fear is very efficient to build addiction. And automatically, no one decided to do this, but the algorithm, because the algorithm say, I will give him the thing he did like yesterday. The algorithms are building polarization, dissensus, fragmentation of the opinion, and a lot of other issues we have to face. So that's the short story and the important story. So I don't know, maybe around 2015, we started everywhere, but especially in Europe, to think that we have to regulate this. But here, of course, we had other issues. So at these times, I spoke about the triangle of death, because we could have made 3 mistakes. So the first one is not to do enough. So to expect that automatically the market will regulate itself, etc. We can obviously observe that it's not the case. The second one would have been to give too much power to the companies. A company is just a company. A company is not a democracy. A company has just a responsibility in front of the shareholders. And we cannot ask, for example, to Mr. Zuckerberg or anyone to decide alone without any transparency, without counterpower, without way to contest the decision, with, I don't know, a big AI that we cannot audit. We cannot ask them to filter the content of the humanity without, yes, accountability and responsibility. And the third one, of course, would have been to give to the states too much power and to build a kind of Orwellian world where the state decides this is right, this is true, this is unacceptable, blah, blah. So during maybe, I don't know, 4 or 5 years, everyone did exchange a lot around this. And then I don't know how, but a new consensus did emerge. Someone said, but we did this with the banking system. We did build a compliance framework where the banks has a duty to be accountable, to be compliant, but we don't tell to the banks the micro decisions they have to do. And someone said, but we should do the same with the social network. And the DSA, I can testify, I can witness that I'm very, very proud to be an ambassador and to promote the DSA now. It's a very elegant solution because the DSA says, okay, the companies will have a duty to make a strong risk analysis and to explain if they have the risk to create a new January 6th, you know, the attacks of the Capitol, and or if they did fix this issue. And they will have to make this in front of a strong, independent authority with strong audit capacities, power. So if someone say, no, with my company, there is no risk of a new January 6th, this authority, which is not the government, which has a duty to keep the information secret, can say, okay, show me your algorithm, show me your data, show me the book you did send to your 30,000 moderators, show me the content you did delete, prove me that people have a right to contest your decision and that someone will read the contestation, etc. And so first a risk analysis and then a fixation plan. And again, the same authority will have the right to say, okay, I don't trust you. I want evidences. I want data. And what we do expect is that year after year, in this conversation between the companies and regulation authorities, we'll make more and more precise and efficient rules. That's the DSA. As I said, I feel, but we will exchange now with everyone. But I feel that is a very elegant solution because the government won't decide the algorithm nor the content. They will just check through an independent authority if how serious the companies are accountable. Just one word, but very quickly about the DMA. The DMA is another very important issue because we do observe that most of those companies, let's say the name, the social network or the platforms, have a platform strategy. And when you have a platform strategy, you do control an economic ecosystem with very specific approaches because you don't control them like this. You create, you share resources, data, electronic ID, payment system, and you are the ground of an ecosystem, and you do control the ecosystem, but because you are the ground, and that's very difficult to see if someone has a new monopoly position, and if someone has if there is a risk of unfair use of this strategical position. So we decided that, and we are very precise here. So this is a DMA, Digital Market Act, for systemic platform, for gatekeeper. So a platform that does control all the economy. It can be, of course, Google, it can be Facebook. I don't know, it could be the GSM system. So, you see an infrastructure that does control a huge part of the economy. A systemic, a gatekeeper. So for this, we have concurrence authorities, we have a regulatory framework, but before the DMA, we did act after the monopoly and after the abuse of this monopoly. And now those authorities, not us, the government, those independent concurrence authorities will have a right to make ex ante decision. So to say, no, here there is a risk. You are going to a strong control of an important part of the economy. We start the discussion before you destroy all your concurrence. So that are actually, as you said, Jovan, I feel like you, two important set of rules. And with the GDPR, which protects privacy and the exchange of private data. Now, Europe, we have tools to protect the privacy, to control monopoly on the market, and to guarantee a level playing field, and to impose a serious, real accountability to big tech companies. And now we have to play with this. Probably it will take a few more years to have a good organization, but we have, I feel, a good framework.
Thank you, Henry, for great summary, historical, a bit of, if we can call it, digital confession when it comes to the governance, but in the same time, as you said, things have been developing gradually. We didn't know 20 or 25 years ago how things will develop, how fast and how dramatically. And in chat, we had some references for, obviously, Section 230 of Defamation Act 1996. But you, in a way, summarized the developments also on EU. Digital Market Act, which you didn't focus that much, is in a way built up from long processes and a lot of experience in Brussels in dealing with the market monopolies. Digital Service Act was much more careful walking into new, let's say, new regulatory terra nullius. And that's a great summary. I don't know if you have to leave it immediately.
I'm staying with you 1 hour.
Okay. Okay. Just one more question. Now you came into climbing to the base, whatever camp of a station. Now it will be next step. What you envisage as some sort of roadmap which will be passed to Czech presidency? What are the next steps till the end of the year, practically, on both acts?
So on both acts, they were adopted. So now it's time to implement them. So maybe it's less a matter of presidencies and more a matter of member states, and maybe creating a framework for the independent authorities to exchange together, and maybe for the states to ask them some precise question to be aware about this, etc. Now, our next project is another, but a complementary project is to promote and maybe to finance the digital commons. Because another way to be sovereign states and democratic countries is to be sure that everyone can innovate within digital commons. So something that you cannot be excluded from. That's the important aspect of commons like Wikipedia, free software, OpenStreetMap. So commons can be data or software or even infrastructure. And we have the feeling, a lot of people, not just French, maybe the ancient people from the digital revolution, that we are losing a bit the public core of internet and the digital commons. Open standards, for example, is something very European. Quite every open standards of internet were invented and promoted by European countries, even Bluetooth or ADSL or web or Linux, etc. And we have to be sure that we will continue to innovate and live in a world with enough commons. And this is I like also this approach because this is a more concrete and bottom-up approach. It's not regulation, it's not legislation, it's just sharing resources for innovators. It's an empowerment strategy. So maybe the next thing, and the thing we'll share with the Czech presidency, is to promote and why not finance digital commons.
Just for those of you who are new, Henry, Ambassador Verdier, has a very interesting background also from open data community. Therefore, he's now combining this with diplomacy. And as open is becoming more and more used term around open RAN, open standards, open issues. We are putting it at Geneva Internet Platform on our policy radar to follow, and probably in June we'll have an event on the commons and open. And thank you, Henry, for bringing this. Please stay with us as much as you can. If there are any questions specific for you after you leave for G7 meeting, we'll pass to you. We now move to Brussels, to Prabhat Agarwal, and to hear more, let's say, nitty-gritties on these developments, on these two important acts, after Henry set the wider political and diplomatic canvas for this painting. What are some details or some important elements? Prabhat, please let us know.
Yes, thank you. Thank you very much for giving me also the opportunity. I'm Prabhat at the European Commission. I was in charge of the development of the DSA and the DMA here, and for the Commission I was negotiating, and now we are indeed switching to the implementation of these two important legal acts. I think in a nutshell, we wanted to reform the regulatory framework in the European Union for big tech platforms. And maybe instead of taking you through the individual details, and Ambassador Verdier already gave a really brilliant introduction to many aspects, I wanted to summarize a number of challenges that we faced, which make it, which we had to take into account specifically. So first of all, the population of regulated entities, what we generally call platforms, is unlike in the banking sector, or unlike in the telecom sector or other regulated sectors, or the energy or railway sectors, is a very heterogeneous population. There companies such as Amazon or TikTok, have limited things in common in the way that they operate. Yet they have some fundamental concepts in common, namely that they are driven by data-driven network effects, those that were first analyzed by Nobel Prize winner Jean Tirole, who was already mentioned before. But from looking from a distance, the individual companies in the population, what we broadly call online platforms, are potentially very different. And the sector that we are dealing with in the big tech sector is very much heterogeneous, and the different services are not immediately substitutable with each other. So you can switch one bank and go to the next one. It's basically the same service, or you can switch a telecoms operator and go to the next one, and it's basically the same. And the trains in Spain are very similar to the trains in France or somewhere else. But this is not the same on that platform. So this is one big challenge that we had. Second big challenge is that these are companies that, unlike the other sectors that I mentioned, is that they are not reliant on a physical infrastructure. So these are data-driven companies that are changing fast. They are evolving very gradually. They have grown enormously, much quicker than any other sector in the past, and with that come also particular challenges in designing an appropriate regulatory framework. So that was challenge number 2. Challenge number 3 was, and this was already mentioned, was to not fall into the trap of trading off freedom of expression with user safety. What we wanted to do is to do both: improve protections for freedom of expression and provide for a higher degree of user safety online, notably when it comes to the proliferation of illegal content on platforms, but also, as we have seen most recently, the concerns around manipulation of platforms, for example, in the context of elections. So this balance and this going hand in hand of freedom of expression and user safety is really something that we've been thinking about for a long time. It's not an easy equilibrium, and some people have also gotten it wrong in the past, either on one side or on the other. So as part of this reform, we had to indeed reform the equivalent of the Section 230 Communications Decency Act, the intermediary liability provisions. And so this was part of our reform progress. And we added on a catalog of so-called due diligence obligations on top in the DSA. The fourth challenge we had, which is more in the DMA, was to make sure that we regulate certain business practices of so-called gatekeeper companies in the DMA, while keeping the markets open and innovative and contestable. So this was also a very important challenge, and this was rooted again on a very deep analysis of the market dynamics that are fundamentally different in data-driven platform markets compared to traditional markets where network effects are typically much weaker, and lock-in situations develop less easily and less frequently. So I would say, in a nutshell, those were our 4 big challenges: to define a regulatory framework for a very heterogeneous set of companies that are tied together by these data-driven network effects. That's number 1. Number 2, to have a regulatory framework that is flexible enough for when the sector evolves, that we can respond to it quickly and flexibly. And over the last 5 years, we've had a lot of new phenomena that were appearing quickly, whether it's disinformation, or it's the sale of non-compliant face masks in the times of COVID, or many other examples now that we are witnessing also in the context of the war against Ukraine. Just to recall, our third big challenge was to increase both freedom of expressions protections in line with international human rights norms, while at the same time providing for adequate protection of user safety. And this included the reform of the liability protections, and finally to have a framework for fair and contestable market that is pro-innovation, but protects also small innovators in markets that are very strongly shaped and determined, in fact, by big gatekeeper companies. So maybe in a nutshell, I stop here. Those were the big elements. We've been working on these proposals for quite some time in the European Commission, together with member states and third-party stakeholders. Had many public consultations. The most recent one had many thousand replies. the argumentation in the European Union before presenting laws have to be based on so-called impact assessments, where we have to bring together all of the evidence, the different options that were analyzed, the cost and benefits of each of the options have to be compared, and this was done very carefully. And so the process then recently came to a conclusion, and now we expect the text to be finalized. We're in the technical finalization process at the moment, and then we will move towards the implementation. And that's my final word. The implementation will be entrusted to the European Commission, where we will take powers that the European Commission at the moment has under antitrust laws, and they will apply them also in this area to platform regulation overall. With this, Giovanna, I stop and I look forward to the questions.
Thank you, Prabhat and Henry. I'm teaching at the College of Europe in Bruges, and I'm teaching digital diplomacy and negotiation and other issues. But after hearing what complex and complicated issue two of you had to manage together with your colleagues, I'm sure I will advise the leadership of College of Europe to invite you to some special session on the negotiating complex issues, because it's really fascinating how many different perspectives you had to handle, from technology, inclusion, law, interest of member states, relation with United States, and it's really complex exercise. Now we will be. I'm always curious in this negotiation when I see the text to read between the lines, and what are the sort of issues that were focused. That because in any text you have most of the time spent on few words, on few phrases, that at least my experience from negotiation. Therefore, if you can, you and Henry, reveal it later on as much as you can, that would be great. I know the document and paper is still in the process of political takeoff, which is delicate phase. I will now turn, before we pass floor to Marilia, I will turn now to my colleague Pavlina Iterson, specialist for these issues, who Pavlina was following chat. Pavlina, what questions do we have from chat for our two speakers, or comments?
Yes, thank you, Jovan. So we do have quite a lively discussion in the chat. Sorry about my camera, I'm back. First, Richard and Michael jumped right into the global arena and started to discuss how these new regulations will interact in different liability regimes, specifically with Section 230 of Communication Decency Act in the US, and how the different concepts of freedom of speech between the United States and EU will interact with each other under these new regulations. So that is the first question, very interesting one. Second question, David Fairchild asked whether the panelists could enlighten the relationship between DSA and DMA and linkage with the AI Act coming up. And then we had discussion about question about impact on sellers using intermediary platforms and whether they'll be exposed to the new regulation. And the fourth question is there a rigorous analysis of market power and substitutionality? Thank you, Carl Frank, for this hard word, among platforms and platforms to brick and mortar. So I'll leave it to the panelists to pick their favorite ones. Thank you.
Thank you, Pavlina. Let's hear, Andrea, if you're still with us, let's hear from you. And then we move to Prabhat to reflect. You heard the questions. Basically, compliance with other liability regimes, market power linked to the future AI regulation. You can pick up any of these four questions and let us know your views.
Briefly, I'm not a specialist of Section 230. Yes, I feel, but that's just a feeling that they should reconsider the exact status of those kind of platforms who are not just hosting services, but metamedia with an editorial publishing policy and with a lot of curation. Regarding the First Amendment, I have here a strong position. There is nothing to do with the First Amendment for two reasons. First, the First Amendment forgive the government to control content. not the company. And actually, if you do observe, they all have for a long time strong content policies, and they all forbid a lot of content for a long time. Try to use a picture with a nude, naked people as try to use it on Facebook, and you will see the freedom of speech of the platform. So they have content policies. They have the right to have content policies, and that's the most important. And the second reason, we don't pretend to control the content itself. We as states or government, we won't write a list of prohibited content. We'll ask the companies to show us how they manage the issues with this content, the polarization, terrorist content, violent extremism, hate, or disinformation. So we try to regulate. Yes, someone wrote this in the chat. The algorithmic policy, not the content policies. So from my perspective, there is absolutely no concern with the First Amendment. And when I do exchange with a lot of US authorities, they recognize this. They just say that they may have some trouble politically because, of course, in a political controversy, that's easy to say, but we are the country of the First Amendment, we don't want. But actually, legally speaking, in front of a judge, there is nothing to do with the First Amendment. For the sellers, from my perspective, because we do regulate, or we will regulate, the algorithmic content policy, I don't see any strong consequence for sellers. So maybe you have to know that there is another text that we are thinking about in Europe, which is for political advertising, to regulate or to limit comportamental, behavioral advertising for political advertising. But that's just for in a very specific field, which is political.
Thank you, Henry, for these points. Therefore, your summary is First Amendment, no major problem. We'll hear from Prabhat on the Section 230, no major issue for sellers. Maybe Prabhat, you can also reflect on the David's question of link to the emerging AI regulation, which is coming. Over to you, Prabhat. Any of these 4 questions, and particularly these few which remain to be answered.
Sure. I mean, maybe just the AI Act has a fundamentally different scope. It deals with any type of artificial intelligence. It's not just limited to online platforms or digital services. So it also covers, AIs in other hardware applications or in social scoring situations. Those kind of situations much different from just the issues that we are looking at the moment. And the basic issue around the AI Act is that it seeks to lay down criteria for what constitutes a high risk AI application. And in that case, if you fall within these criteria, then you have to carry out a particular ex ante assessment of these risks, similar to kind of documentary ex ante checks that you do, in other areas, like, regulated areas. So the link with the Digital Services Act is mainly in the area of algorithms that are used for content moderation. So that's really where there's and there the DSA goes, the Digital Services Act goes further in terms of the rules. We have, for example, rules that give power to users to choose how a particular recommended system algorithm is presented to them. They have to platforms have to present different alternatives, including one which is not based on profiling. That reflects a concern in the European Union about excessive data extraction, personal data extraction for the purpose of optimizing services, what's broadly referred to as the attention economy in these things. So there's an interface between the two acts, but they are quite distinct. I just want to add one thing in terms of sellers, because I think that the Digital Services Act and also the Digital Markets Act, they do have a number of wide-ranging additional benefits for sellers, and I can name just a few. First of all, I think that in the Digital Services Act, there's a very important distinction which is linked to the liability immunities on whether the platform makes it clear that they are interacting with whether if you're buying from a third-party seller or from the platform. And often this is not clear to the seller. You know, you go to Amazon or you go to some other website. I mean, recently there was a case in France about a holiday renting website, and for a normal user, it was impossible to tell whether this is you're actually taking a product which is being made available by the platform or by a third-party seller. So that is an important distinction that is made in the Digital Services Act. On the Digital Services Act, sellers get another range of obligations, but also many protections. For example, delisting of the service from a platform is no longer possible without any procedural safeguards. So you can't just be kicked off, you know, of a platform. So there are dispute resolution mechanisms and out-of-court dispute resolution mechanisms. There's an obligation for transparency, for statements of reasons. If you get removed or your account gets suspended, or content gets removed, you have to document, the platform has to document why it has done so. So these procedural safeguards are quite important also for sellers on platforms. Similarly, in the Digital Markets Act, actually there is a prohibition for the platforms to use third-party sellers' data for their own benefits, you know, and that's a very important thing that we've come across quite often, that third-party seller data is being used, or that you're locked into the payment service of the platforms, for example, in the context of app stores. So I'm just giving some examples, but there's actually quite a lot of benefits for concrete benefits, you know, not just hypothetical, but really practical benefits for sellers who are intermediating through platforms. And the whole idea is to lower the barriers to compete, because and to improve the contestability of markets as well. To the first question on freedom of expression and the First Amendment, I think that maybe I can just recall that I think Ambassador Verdier was absolutely right that, like the Charter of Fundamental Rights in the European Union, the First Amendment constraints government action. We have aligned the Digital Services Act in particular to international human rights norms, whether it's the ICCPR or the European Charter of Human Rights, and we've been very carefully basing ourselves on the existing case law, international human rights case law, when it comes to intermediary liabilities and obligations of platforms. And so, in what I want to say is that we believe that the Digital Services Act is really very strongly furthering protections also for fundamental rights, and notably freedom of expression. Is fully consistent with international human rights norms, and the US is also signatory to international human rights norms in the area of freedom of expression. Lastly, I think I would say that in the context of the Trade and Technology Council, where we're working with the United States government, also on platforms, we have a working group 5 dedicated to platform governance. We actually have a really very close and very constructive and productive cooperation with the US government. And we have started some concrete cooperation projects around the DSA, notably on issues such as algorithmic amplification, on data access for researchers, on transparency standards around content moderation. So there's ample scope for productive and multi-stakeholder engagement around these issues and international cooperation.
Thank you, Prabhat, for giving us a bit of a small print. I think it's important to know. There was a question for Henry and you and Marilia later on from Carl Frank, which is interesting question. We take assumption that there are monopolies and not substitutability of the platforms. But Carl asked for some evidence, and that could be later on. We can reflect on that, and there are more and more messages and questions. Now there will be 2 places where the DSA and DMA will definitely land. One is Luxembourg and European Court of Justice. I'm sure that there will be court cases that would be interesting to anticipate. And the other is Geneva, where the links to the trade negotiation, human rights and standardization will be happening. And this is the intro for Marilia to reflect on the global impact. We already heard on transatlantic dynamics with the 230 and the First Amendment. Marilia, what are the other impacts, broader impacts of DSA and DMA on the global scale via Geneva or directly to the continents and countries? Over to you.
Thank you, Jovan. When I saw the lineup of speakers to this session, it was really clear to me that other speakers could provide an overview of the political background and the key provisions of these instruments better than I could. So I appreciate your question, Jovan, because it is related to putting these instruments into this broader regulatory context, and that's what I'm going to try to do, and also to make some connections between these processes and other digital policy discussions that are taking place, especially on cybersecurity and e-commerce negotiations taking place at the WTO. I think that Ambassador Verdier started with a very important point, historical point, because the first thing to bear in mind is that the regulators' approach on regulating the digital economy has changed remarkably over the years. There was a majority of view that thought that the digital market should be left alone in the beginning. And I think that it was mostly based on the fact that, first of all, platforms and social media, they were seen as strategic spaces of guaranteeing free speech. And we may recall, for instance, how we praised the role that social media played back in the Green Revolution in Iran or the Orange Revolution in Ukraine. And now we see this in a more nuanced manner. There was also an understanding that any kind of regulation would stifle innovation. And we really saw regulation and innovation as two things that were at odds. And we're happy to know that this is not the case anymore. We see that innovation requires regulation many times. And we also understood that the digital market would be so dynamic that it would have the capacity to almost readjust and recalibrate itself. We believed that the principle of there are no permanent favorites that has been elaborated by the technical community, which actually means that the architecture of the internet is open to any type of innovation and agnostic with regards to the players that are operating it would be enough to foster a competitive environment. And we know that this is not the case anymore. So the idea back then was, if it ain't broken, don't try to fix it. Laissez-faire. But we came to the conclusion that the digital economy, if it's not broken, is showing some important cracks that we have discussed here in terms of the shortcomings of limited liability and the proliferation of disinformation, of harmful speech, illegal content, and economic problems. We see over the years how many international reports from the World Bank, from the World Economic Forum, from UNCTAD has shown how inequality has grown in terms of the distribution of wealth in the digital economy. And we see more concentration happening in the market vertically, horizontally. We see companies taking space in the market, Amazon owning cloud services, Facebook owning backbones, and so on. So against this background, I think that the whole spectrum of countries from US to China are currently looking at these two areas, liability and competition. And they are recognizing that we do have a problem. They are taking steps either to correct this with policies being put in place right now or in the near future. And I think that this creates a political momentum, and the conditions really face the power of large tech companies, which, to be honest, they are more powerful than many countries, many governments around the world. And this could also create the conditions to engage in more healthy conversation about how to reach international harmonization when it comes to finding legal solutions. As we heard, this is already happening in the transatlantic relation with the US through the Trade and Technology Council. But I think more needs to be done in relation to China. And to illustrate these points, I think that we have touched a lot upon on what is happening in the regulatory space in the US. There has been a quite dramatic change in terms of regulation. I think that there is a growing view that the platforms enough, they will not foster a democracy or the growth of small businesses or innovation. So there's plenty of regulation that are coming up. But I think that we didn't mention China enough in this conversation. So that's where I would like to focus a little bit, because China has passed recently several regulations on data protection, for instance, which also applies extraterritorially, such as the GDPR. They have new laws on cybersecurity, on algorithm transparency, and competition. And although the so-called crackdown on companies is usually portrayed as a product of President Xi Jinping's authoritarian stance. These measures, they are actually aligned with ideals which are much more deeply rooted in Chinese socialist political system, which is politically translated into the banner of common prosperity, which is the umbrella where all these different digital policies lie. So the idea is that the overly rich are not a good social model if their riches are not actually translating into commensurate benefits to the society as a whole. And the Chinese economy is really suffering from the approval of these recent measures at the moment. They lost in terms of fleeing foreign direct investment more than 1 trillion by now. And it's interesting to see how in Europe, the DMA is being largely welcomed, but at the same time, norms to foster competition in China, and I'm not entering the merits of the nitty-gritty of these norms, but they get labeled as anti-liberal and authoritarian by Western media. And I think that does not help the establishment of dialogue that I was talking about before, which I think is really important at the moment. So we talk a lot about the Brussels effect, which is undeniable. If you look at how the GDPR has influenced data protection regulation worldwide. But I think that in upcoming years, we will talk more and more about the Beijing effect in terms of regulation too, because of many different factors. First of all, the market size, just like Europe, China has a size of a market that most companies cannot ignore, so they need to comply with regulation to operate in China. There is an increasing number of companies and countries which are consuming Chinese technology. And there's also the fact that Chinese regulatory model could be closer to the reality of other Asian economies, making it perhaps more feasible as a model for them to adopt in terms of exporting regulation. I think China is well positioned there. So I think that the bottom line is that Chinese regulation will definitely influence the global conversation that we're having here in terms of regulation. But I feel like Europe also has a very distinguishing competitive advantage in terms of regulation, because it is based on an approach that puts individuals and their rights at the center of policymaking, as we have been hearing here. In the US, it's interesting that because the discussions are happening around an economic angle of competition, election interference. In China, they are happening from an angle also economic of social prosperity, and also controlling speech, trying to promote a positive online environment, as they name it, and promoting social harmony. But China aims towards a more collective perspective in which it's my understanding the individual gets a bit lost. And I think Europe has a key role in sort of putting the individual and its rights back into the picture in terms of regulatory approach. And that is quite interesting. Sorry, Jovan, please.
Thank you, Marila. It's a great, because this is true that we often have a blind spot when we discuss this issue, focus on a few places, but dynamics and what's happening in Beijing is extremely important. We have Brussels effect, but maybe Beijing effect, definitely Washington traditionally. And we hope some Geneva effect as a space of the, let's say, soft governance and soft power. Let us hear quickly from Henry. We have about 5 minutes, and accept if I, with your permission, get extended for a few session for a few minutes. Henry, your comments, and then we'll hear from Pavlina about the questions and the answer to the questions. Over to you, Henry.
Thank you very much. So I completely, Marilia, share your concern. Of course, China want another internet and another web and another company's regulation. And we do observe a lot of approaches, especially in the ITU, of course. I share with Jovan the idea that, I say this publicly, that Geneva is a very important ecosystem, because this is the ecosystem of technical multilateralism. So in Geneva, people know what they are speaking about concretely. More than, I can say this publicly, more than in New York, for example, which is more political. Now, I wanted to share with you a very important idea, and maybe that's why I would love you to remember. If you remember my short story, we have, I think that we, Europeans, we have to be very precise about the difference between internet, which is, as I said, decentralized, open, free, neutral, and with a good multi-stakeholder governance that we have to protect. And I'm not sure we'll succeed in, because we have a lot of cloud, but the other way of cloud upon this multi-stakeholder governance and this unique internet and the web and the companies. And I want to tell publicly that Facebook is not the internet. And actually, it is not even a continuation of the internet. It is a private space with private rules built on top of the internet. So Facebook or another social network, it's not decentralized. It's not open. I don't know how it works. I don't see the algorithm. It's not free. I cannot go within Facebook and make my business. It is absolutely not neutral. They have algorithms to filter and propagate content everywhere. So obviously we can, in the same way, stand for the open and public and free and neutral internet and ask for a regulation of this kind of companies. I'm very comfortable to make both in the same diplomacy, because it's completely different. And too many people, even in France, too many journalists, for example, tell me, but I don't understand. Are you against regulation or pro-regulation? Are you against free speech or pro-free speech? We are, but most European, for the free, open internet, that empowers the people to make, and for big monopolistic companies regulation. And I saw a comment in the chat. In the DSA, we have, and we did negotiate a lot, a very precise definition of systemic actors. They have to have more than 40 million users every month in more than 6 countries, and blah, blah, and blah, blah. And there is a strong definition. So it's not every company that we don't like. Thank you.
Henry, thank you. And this partially answered to Carl's question, but we'll reflect more on that in the follow-up on the evidence on that. Now, we have just 2 minutes more. With your kind permission, I will just slide a few minutes above. It may make me, in the time precision country of Switzerland, maybe persona non grata, but I think it's so interesting discussion that I will be tolerated. Now, Pavlina, back to you for the questions, and then in particular, Prabhat and the other panelists for the answers. Over to you, Pavlina. Twitter style.
Thank you, Johan. We have 2 questions left, so I'll be quick. One is related to the algorithms. So the question is, generally governments refrain from seeking source code of algorithms from digital platforms. Why? And why regulators use our algorithms to detect biased algorithm use of technology to regulate technology, basically. And a second question is a more general one. DMA and DSA do impact regular functioning of supply marketplaces. Where is the line between the traditional competition law and DMA and DSA? In a sense where you don't think of DMA and DSA in terms of regulating freedom of speech, but more on the impact on customers and B2B marketplace. So those are the
Great.
2. Thank you.
We move from users, from consumers to users and back. Prabhat, I think the questions are close to your core expertise and experience from negotiating. Could you make a try to comment on these 2 questions, on AI and the question of competition, and the second one? Over to you.
Well, it's very, very briefly, Twitter style, as you say. I mean, algorithms in the Digital Services Act, there are 2 elements to algorithm regulation. One is to empower users to know what's happening and to give them choice. This was already, Marilia stated it very much, our sentence. Second is to allow experts to inspect algorithms, including regulators. So those are 2 levels. Primarily for an end user, like a normal person, in disclosure of the source code is not something that is useful, because I mean you need to have kind of multiple PhDs in computer science to be able to understand them. But they can, under certain circumstances, be inspectable in the context of a violation of certain rules, but it should not be a precondition for markets. It's a little bit, you know, when you have a car, as a user, you want to be able to drive the car and understand how it functions. You know, the user manual needs to be clean and clear and easily understandable. You want your garage, the repairman, to be able to open the hood and inspect the engine, but he does not need to know the trade secrets of the manufacturers of the car. So it's a little bit similar. I mean, sorry for the simple analogy, is that as a user, I need to know how the car functions enough so I can drive it. It needs to explain its functioning to me. I want to be able to take it to a garage so somebody can expect if something is wrong. In that case, this is a bad analogy, but this would be the role assigned to regulators. And then that still does not require knowledge of how the car was actually manufactured. So it's not a great analogy, but maybe just to give you some insight in how it. And certainly we will use technology. And some member states, notably France and others, have already got great prototypes on how terms and conditions are changing, monitoring that, or on how to determine bias in algorithmic systems. And those tools will be essential in the regulatory function as we go forward. So certainly we can use it. And the question interaction with competition law is really interesting. And actually, in the impact assessment of the Digital Markets Act, we spent a lot of time. Note that we did this initiative together with the colleagues responsible for antitrust enforcement, DG Competition. It was a very interesting experience. I think one of the key differences is that antitrust enforcement is ex post. It happens after the fact on a case-by-case basis for an individual company that is abusing its dominance in a particular well-defined market sector. What we are doing in the DMA is quite different. Is the opposite. It's what we call ex ante. It's prior to an abuse. It just gives signposts that certain types of behaviors, so-called do's and don'ts, are not acceptable. Why? Because they have been demonstrated to limit contestability of markets, entrance into markets. And they are recurrent features of many data-driven network effects that we have documented in the background material and in the antitrust cases that we have come across. So this is the big difference with antitrust enforcement that we call it. This goes ex post, and ex post also has to be said is certainly also as still possible. And you will have seen that the European Union has, for example, opened a case on recently just on Apple on the access to the payment infrastructure inside an Apple iPhone for potential anti-competitive practices. So those investigations will continue to be pursued.
Thank you, Prabhat, for this really comprehensive and clear answer. And with this, I would like to thank all of you who attended the session, made an interesting comments, and in particular our panelists, Ambassador Henry Verdier, Mr. Prabhat Agarwal, and Ms. Marilia Maciel for really not only giving us broader context for this new issue that we'll focus on, but also focusing on specific details. It is the first step on the long journey. Please stay, keep involved with us. We'll send a summary of the discussion, and we'll be following carefully developments on DSA and DMA in particular with regard to the links between what's going on in Brussels and Geneva dynamics and Geneva ecosystem on the question of e-commerce, human rights, standards, and many other issues that are triggered by DSA and DMA and that are likely to come into the focus on policy discussion in Geneva. I wish you a nice day, morning, afternoon, evening, wherever you are located. Stay connected to this discussion and Geneva Internet Platform updates, including newsletter, which is coming tomorrow. All the best. Bye-bye.
Recording stopped.